Performance rights. Concept A. Importance. The definitions provided by the Korean copyright law regarding performance rights can be found in Article 2, Section 3, which states public performance shall mean the presentation of a work, a performance, a phonogram, or a broadcast to the public by acting, musically, performing, singing, narrating, reciting, screening, playing, or other means, and shall include transmissions, excluding interactive transmissions, that are made in a connected place under the ownership, possession of the same person. And Article 17, which states, the author shall have the right to publicly perform his/her work. The right to perform publicity. The right of public performance provided in Article 106, Section 4 and 6 of the American copyright law is different compared to the performance rights provided by the Korean copyright law. The difference between the two rights lies in the scope. Unlike the American copyright law, which includes cable broadcasting and wireless broadcasting, interactive transmission under the right to perform publicity, the Korean copyright law includes them under the public transmission right. B. Methods of performance. Screening mainly refers to the displaying of image-based works such as movies and pictures on screens and other projection mediums. Other projection mediums can refer to the screens of computer monitors, television receivers, and works displayed on a building's walls. Screening is a large concept that includes all acts of visual and auditory display on projection mediums. However, screening is not limited to cinematographic works, as non-motion works, i.e., pictures and drawings, and works that are expressed through charts and texts can also be displayed to the public. Therefore, displaying works through overhead projectors during seminars and lectures are also included as screening. As performances also include playing. The transmission of recorded musicals and stage performances are also the subject matter of the performance right. Therefore, the transmission of commercial music records and videotapes at music rooms, coffee shops, bars, department stores, sports facilities, and restaurants are also included as performances. Generally, the display of original or copies of artistic works, photographic works, and architectural works to the public are accepted as exhibiting and not performing. But due to the recent development of digital technology, new types of art, namely media arts, have been introduced. Unlike drawings and sculptures, which are representations of a certain model at a tangible medium, these new types of art do not require tangible mediums, as they are expressions made through videos. Therefore, the differentiation of exhibiting and performing today should be based on whether if the work is displayed through a tangible medium or through a non-tangible medium. 3. Definition of public. As Article 2, Section 32 states that public refers to a large number of unspecified persons and also includes a large number of specified persons. The definition of public in the Korean copyright law includes open public and closed public. The term specified individual refers to a specified and limited public, which is a group of people exceeding the scope of personal relations. Therefore, the subject matter of performance rights is elucidated by determining whether a certain venue or group can be accepted as public. Examples of venues or groups recognized by the Korean copyright law includes assemblies made by political parties and general assembly conducted by organizations, and excludes weddings, orchestra rehearsals, and club meetings. However, as the Korean copyright law includes transmissions through equipment as a method of displaying, the public can be inclusive of multiple individuals in different occasions and/or venues. 1. Ownership and possession. Ownership and possession, provided by Article 2, Section 3, is an emphasis made by the Korea copyright law in determining the subject matter of performance rights depending on the number of business entities in a specified venue where a work will be displayed. The area of a business entity possessing multiple floors in the same building or multiple buildings connected to each other is accepted as a single venue, due to the reasons that the area of possession is blocked from the outside. In such cases, wireless and cable transmissions are accepted as performances. On the other hand, if multiple business entities exist within the same specified venue, wireless and cable transmissions are perceived as broadcasts. The application of ownership and possession results into adverse effects as the transmission of commercial music records in department stores become performances, while the transmission of commercial music records in a shopping complex under identical conditions become broadcasts. 2. Connected venue. Connected venue generally refers to a single building, but it can also refer to multiple buildings if they are inherent with close locational relevance. Schools and department stores composed of multiple sections, i.e. classrooms and stores, can be included under this concept if the buildings will be connected by passageways. However, if no physical relation would exist between the buildings, it cannot be accepted as a connected venue. A large university campus where buildings are built in different areas cannot be accepted as a connected venue. Although some parts can be accepted as a connected venue, the campus itself cannot. Similarly to that of ownership and possession, the application of connected venue results to different subject matters, as transmission made in connected venues are performances while transmission made in separate venues are broadcasts.